Ladies and gentlemen, I now invite Dr. Sally Engle Mary to deliver the Convocation Address. Dr. Mary.
Thank you. It is a great honor to receive this degree and a particular pleasure to receive it from the McGill Law School, an institution that I have long admired for its commitment to social justice, to human rights, and particularly to legal pluralism. I admire its commitment to taking a socio-legal approach to understanding law in society, its focus on international as well as different forms of domestic law. And these foci have really contributed to the very strong visibility and high international reputation of the McGill Law School. And today I want to talk a little bit in particular about the value of a focus on legal pluralism, which I think is one of the things that you students have acquired from your education. And I'd like to say a little bit about how helpful this is, both for practicing and for academic lawyers. It seems to me that this is an idea that you may want to hold on to as you move out into the world. When I talk about legal pluralism, I'm not talking about it as a theory of law or necessarily an explanation of how law functions, but instead a description of what law is actually like. It provides an invaluable guide for thinking about law in its multiple instantiations and intersections, and to paying attention to alternative understandings and practices of law, particularly among the least powerful members of society, which of course is a very important issue to consider. It seems to me that legal pluralism offers three critical perspectives on law to hang on to. First, it shows that law is all over, in everyday life, not just in formal legal institutions. Law defines identity, such as citizen or alien. It defines who can use which spaces. It provides a sense of belonging through mechanisms such as birth registration. It offers security of ownership or fails to provide security of ownership when it's non-existent. And it serves as an authoritative source for creating knowledge and history. And this is whether we're talking about international tribunals of criminal justice, university, judicial institutions, or even local level organizations of gang members that have their own internal norms and principles of handling conflict. The second point is that these myriad instantiations of law are inevitably fragmented, inconsistent, and contradictory. They are bricolage built up from practice, history, and the legacy of efforts to solve earlier problems. They may be chaotic and incoherent, but they often develop from local practices and may be more attuned to local situations than state law is. They can, of course, also be more oppressive to vulnerable populations, such as women or minorities, than state law. So it's not that they're always superior, but they are certainly another domain of law that needs to be recognized. The third fundamental point is that these systems are constantly interacting with each other and redefining each other. Law is, in practice, shaped through the interactions among multiple legal orders. I'm going to tell you a couple stories about how I came to these perspectives. I didn't begin as a legal pluralist, but as an anthropologist of law. But I have found this a really valuable analytical framework for many of my research experiences. I'm going to give you three examples of times when the fact of legal pluralism emerged as a really critical consideration in understanding what I was studying. The first example comes from research I did on community mediation in the 1980s. This was a time of great enthusiasm about alternative dispute resolution, which was really an anti-law movement, the idea that we were too litigious. This was a particularly American problem, of course, and that conflicts needed to be carried out of the courts and into local communities. I studied a community mediation program in Massachusetts, and I was struck by the fact that many of the participants thought that they were actually going through a legal proceeding, not an informal proceeding. The mediation program's office was in the courthouse. The parties signed a formal agreement on court letterhead, and the mediators told them that the agreement would be placed, quote, on file in the court. Now, they never explained what this meant. So even though the agreement was not legally binding and the courts never paid attention to it, the participants came to see this as part of the legal system. When I interviewed litigants afterwards, many thought that the agreement would be enforced by the court. This is an example of a legal pluralist intersection. The informal mechanisms adopted the trappings and forms of law, even when they lacked its formal authority. Indeed, people using informal mechanisms sometimes adopt these trappings and forms in order to create the image of a greater authority. I noticed the same thing when I was observing a women's court in a small town in India, and this women's court was handling cases of domestic violence, divorce, and dowry. This had no formal authority in the law, and yet they had constituted themselves as a panchayat. They had a book that they recorded all the cases in, they charged case filing fees, and they issued their decisions on stamp paper. In other words, they used the sort of formality of Indian law in order to validate their intervention. Thus, the formal law system often slides into other modes of dealing with conflict, as informal systems appropriate the rituals and forms of law. The boundaries between these systems are fuzzy, underscoring the pluralism of law in practice, and formal law then slides into everyday life. My second example comes from my research on colonialism and law in 19th century Hawaii. As you probably know, British colonialism in Africa created dual legal systems, one for the colonizers and one for the colonized. This duality clearly enshrined racial and cultural difference and inequality. In contrast, when the U.S. colonized Hawaii during the 19th century, it established, with the missionaries and the people doing it, established a unitary legal system. Many of the early legal scholars were from New England, and they were abolitionists. They did not want anything that looked like a system of slavery, and so they decided that a dual legal system would reinforce those kinds of differences. So instead, they created a single legal system and a single legal code, and gradually transformed the Hawaiian legal system into an American one. This sometimes meant even creating new words for offenses. For example, the missionary-influenced Americans were eager to induce the Hawaiians to shift their rather open practices of sexuality and marriage into the ideal, typical, sexually exclusive, monogamous marriage pattern that it was least imagined to be characteristic of New England. So to prosecute fornication, they had to invent a word for it. They called it mohe kaloe, which means literally rascally sleeping, and they encouraged Hawaiians to peep through the thatch walls of their neighbors in order to uncover instances of mohe kalohe. And I wondered, as I read all the cases and prosecutions of this offense, whether or not the Hawaiians might have been better off with a dual legal system, which allowed them to continue their own family practices. A third encounter with legal pluralism came with my study of human rights. The human rights system represents, of course, another layer of legal pluralism that is itself inconsistent and unevenly enforced, yet is also ideologically powerful. It promotes critical technologies of knowledge, such as modes of documenting violation, and affects the ability of publics to see injustices. I studied the creation of a new human right. The idea that gender violence was a human rights violation was a historically developed phenomenon that started in the late 80s, early 90s, and is now a well-established idea. I looked at the way this idea was used by local organizations and social movements in China, India, Fiji, Peru, and the US. In this case, I found that global norms were translated into local norms, although they may actually have been transformed in the process of translation into something that made sense locally. For example, I studied an NGO in India that was dealing with poor, abused women for whom leaving the marriage was not an option. It was impossible to live alone. They could not have any way of supporting themselves outside of marriage. So these women were encouraged to stand up for themselves in their relationships with their husband. This was not a reference to CEDAW, to international human rights norms, but the fact that women needed to stand up for themselves. And it was legitimated by reference to the existence of these transcendent international norms. So even though they are translated to something different, there still is a relevance for this international legal system. I did another study in New York City where I found women's groups using the language of human rights to build alliances among poverty groups, educational groups, housing groups, who found that talking about all these problems as human rights enabled them to form coalitions. I studied another battered women's group that used human rights technologies of documenting abuses to show how the New York City family courts treated battered women poorly. What might we take away from this brief overview of the analytical benefits of a legal pluralist perspective? Clearly, it warns against seeing legal systems as homogeneous and neglecting the importance of local, community, or religious-based systems of law. It raises questions about rule of law projects that ignore local law. It shows that even if international law, and human rights law in particular, is inconsistent, fragmented, and not fully enforced, such pluralism is inherent in all legal systems and can even open up spaces for local activism. Armed with this powerful concept, I am sure you will be better lawyers and scholars as you seek to promote social justice at home and in the world. Thank you.